SJC-12531, Susan Ciani v. Brenda L. MacGrath, and others.
And I note, I said earlier that Justice Lang was sitting on all cases. I gather she is not recused from this case. So you would have seen it if she were here, that she would have stepped out, and I'm sure she has, but she's not. She's not sitting on this particular case.
Thank you. Good morning, Your Honors. Francis Russell, I represent Susan Ciani, the appellant. Your Honor, the case is before you on 3 questions of law that were reported up from the trial judge. All of those questions stem from the interpretation of Mass General Laws, Chapter 191, Section 15, and the interest that my client gets as a surviving spouse who waives the provisions of the decedent's will. The facts, as have been pointed out, Your Honor, were that Mr. Ciani did a will back in 2000 when he was married to another woman, leaving his estate to that woman if she survived him, otherwise to their 4 children. The wife actually predeceased Mr. Ciani, who subsequently married my client. He never changed his will, and in 2015, he died, leaving that same will as his last will. My client, under Section 191.15, properly filed a waiver of that will, seeking to claim her statutory share pursuant to that law. The questions that were reported up stem from whether or not the rights that she gets as a surviving spouse claiming under the statute give her a vested life estate in property, entitling her to the rights and obligations of a life tenant.
So if she has a vested life estate, she can petition for partition, which was done here.
And that's what was done. We did
Right.
file the petition to partition, and that's how these cases
Right,
arose.
and we've got one property.
The question that was reported up is, does her vested life interest that she gets under this statute give her the right to petition to partition?
Right, and the question I've got is, when we look at the statute, which has some origins, some common law origins, when we look at the statute, if we interpret it your way, does it give the surviving spouse a windfall in that they could get, other than the $25,000 outright payment, more than they are entitled to?
I don't think, Your Honor, if we look at historically what is done here, it gives a windfall at all. In fact, this arose out of that common law where, quite frankly, it was a gender-biased law where it was a widow's allowance. Before that, it was dower, curtsy. And in fact, when you look at the enactment of this law back in 1956, the way the House reported that bill was giving the surviving spouse a greater share of the estate as a result of 191.15. But a life estate in real estate is very specifically granted in the statute, and I think this court, back when it decided Sullivan versus Birkin in '84, said that when it comes to the issue of the estate that we're talking about, that the surviving spouse is entitled to, we're leaving that decision to the legislature. And in fact, this legislature has adopted in 191.15 says that the surviving spouse, when there are children, gets 1/3 of the real estate and 1/3 of the personalty. And if that amount exceeds $25,000, then it gets a life interest with respect to personalty in trust, and with respect to real estate vested for life. There's no clearer distinction between the 2 types of property than is spelled out.
That's really the issue, and my confusion, I guess, stems from the phrase, only the income during his or her life of the excess, right? Whether that modifies solely personal property, or does it also modify, as your sister will argue to us in a second, or a few minutes, real property?
And what I would suggest for Your Honor's consideration is my sister's interpretation that what that does is give this surviving spouse not a vested life interest, but more akin to beneficiary of a trust and a beneficial interest only, not giving those inherent rights that go along with a life estate, is not consistent with what the rest of the statute says. It says specifically with personalty in trust for life. That gives that beneficiary certain inherent rights under the law of trust law to make sure that the property is administered properly using a prudent man standard, invested into an income-producing asset.
But how do you get to petition? How do you get from vested in him and her for life and only the income during her life in excess of her shares above the amount? How do you get from that to a right to petition?
Well, Your Honor, under Chapter 241, if I have an interest in property for life or even a term of years, I'm granted under that statute the right to petition for partition of my interest. That goes way back to the freedom of alienation of property. We don't restrict people that have a vested interest in either a fee,
Don't you
term
have to
of
have
years.
to partition, you need an undivided legal estate, right? Is this an undivided legal estate?
A life estate is an undivided possessory present interest in real estate.
It's
So I would-
it's alienable. You can do with it what you
You
wish.
you can alienate it by sale, but it's measured by the life of the
Right.
original
But-
life
but
tenant,
let
or
me
by petition to partition.
Let me just ask you to put a last point maybe on this. So your interpretation of the statute is that income language only applies to the personal property, does not apply in the next phrase to the real property.
It is, and let me explain further why, Your Honor. As I said, if you look at the statute as a whole, and even then the next following section, 16 of that same statute, where it says, for personal property that's derived from Section 15, there's a process for appointing the trustee of a trust to then manage that property. So that personality, there's an avenue for the beneficiary whose rights are derived unto that trust to enforce them. There's a trustee, there are fiduciary responsibilities to that trustee. If you look at the real estate as something that is only giving that person a right to income, there's no avenue other than having a vested right to the real estate for that beneficiary to get anything. If I own 10 acres of non-income producing land when I die, and my spouse who I've left out of the will gets a 1/3 vested interest for life, with nothing more, not put into the trust, not a provision later for appointment of a trustee, then there's no way for that life beneficiary to get anything out of that property. So unless you interpret this as a vested interest for life, as I believe it's intended, and I believe the legislature certainly discerned it from personality on 2 occasions. One, right in the beginning of that statute. Secondly, in Section 16, and actually later in Section 15, what they say is, if the $25,000 is not readily available through the personality, the person interested, the life tenant of the real estate, has the right to just petition to alienate that much of the property that will be required to pay that $25,000. That is what I believe, Your Honor, supports that position, that it is an undivided interest in the entirety, not a specific.
If we're trying to approximate the donor's intent, where the donor did not include, obviously, the surviving spouse, what about that windfall question I asked you in the beginning, where suppose someone's life estate and they were able to sell it for millions of dollars, right? Wouldn't the donor's intent say otherwise when they
Your
were
Honor,
basically shut out of the will?
In this case, I think it's almost inconceivable that this donor knew 2 things. One, that his marriage was not going to have an effect on his prior will. Prior to the MUPC being adopted, his marriage to my client would have voided that will entirely, and my client would have received her intestate share. It's only the MUPC that has kept wills that were done before a marriage. And this wasn't a will where he divested this wife and said, I'm leaving everything to somebody else. This was a will he had done 15 years before he died, where he didn't even know this person at that time and just left that old will in place, never having done a new will. So to try to infer intent from those facts would be impossible, I believe.
Doesn't marriage revoke the will?
It used to, Your Honor.
Used
Now,
to,
now
not anymore.
it
Okay,
doesn't.
I'm out of date then.
Can I ask you to walk, I have
I just can't follow this statute, I'll be honest with you. Could you walk me through, I'd like to go through the exact language itself. It goes,
This
except,
is,
I'm reading from the statute, except that in either case, if he or she would thus take real and personal property to an amount exceeding $25,000 of value, that part I understand, okay? He or she shall receive, in addition to that amount, only his income, only the income during his or her life of the excess of his or her share of such estate. The share of the estate in this case, there are how many children here?
4 children.
So his or her share is what? It's a what share?
In this case, because she wasn't part of that will,
Right.
her share would be $25,000 of personalty if it's available.
Right.
And one-third of the real property vested in him or her for life.
Oh, but don't, before you do, you say that, but I'm trying to get there from the language. So his or her life, of his or her share of such estate above that amount, her share of such estate, what does that mean?
Well, I believe it's spelled out, and what, if there's confusion in the general
The
language.
share of the estate explained in the latter part of that sentence, or where is it
I
explained?
believe it is, Your Honor. It's explained as to personalty, it's in trust for that beneficiary, for that spouse, for
Okay.
life.
So
As to realty, it's vested in that person for life.
okay, but hold on, but so in excess of his or her share of such estate above that amount, that's all that is a lead-in to the next sentence, the personal property to be held in trust.
Correct.
Okay, so in this case, we have how much personal property?
Let's look at it this way, Your Honor. I think it may point out my
I really
position.
would like you to walk me through the
All right,
sentence.
so the
because
real personal property consists of, could be a Tom Brady jersey autograph.
I know what personal property is, I got it. Okay.
But that produces no income, Your Honor. That produces no income for the
Priceless,
spouse.
though, but it
But
is.
by putting it in trust,
Mm-hmm.
under the beneficiary's petition to have a trustee appointed, that gives that beneficiary rights with respect to the value of that personal property to convert it into something that is income producing to that
Okay. So
beneficiary.
all the personal property is being held in trust. In this case, how much money are we talking about? I mean, how much we got, what do we, what-
Started out, I believe, at about $100,000 of
in
personal
jewelry and stuff like that? Okay. so
cash,
then-
jewelry, whatever.
Okay, so then, and the real property, so the real property here has already been partitioned voluntarily, and it's worth,
Real property has not been, a
Some of it
petition has
has.
been,
Some of it
has been
has.
filed, but it says vested in that person from the date of death of the decedent, which is very much akin to how
so all of the real property is vested in him or her for life?
a one-third interest in that real
And
property.
how do we get the 1/3? Where does the 1/3 come from?
Further up in that statute, Your Honor, it says that he or she shall thereupon take one-third of the personal and one-third of the real property.
That's where we get the share as the 1/3,
Correct.
up above.
And then to the extent those two shares, the one-third of real and one-third of personal, exceed $25,000, the statute delineates and said the amount of personalty in excess of the 25 is held in trust, and the real estate
Okay,
is,
can I ask you to do one more thing for me then? Do the actual math here as you interpret that, okay? Do it in this case, just because
the way the math would work in this case for me, Your Honor, is if I have a vested
I
life.
don't want you to do ifs. I want you to do this actual case, these numbers, do the math.
I don't have the numbers in front of me, but assuming it's $100,000 of personalty.
Okay.
And $400,000 of realty.
Okay, so 100,000 personally what do you say, 400,000 in real? Okay, go ahead.
So the personalty, $25,000 would go outright to the surviving spouse.
Right,
And $75,000 of value of the personalty would be held in trust by a trustee for the benefit of, one-third of the 75, or $25,000 would be held in trust for this beneficiary.
okay. Okay, and then the other part, you got 400,000, so it's 1/3 of that again?
Correct.
1/3 held in?
It's a one-third life estate, Your Honor, and this is where we get to,
And then you're saying, after you get the 1/3 life estate, because it's an interest in real estate, it can be petitioned to partition.
that's correct, Your Honor.
Okay, and by the way, I'm going to ask your sister to do the same math and show me how it works differently, but okay, I appreciate that.
And
That
what
was
I've
helpful.
suggested in our brief, and I would suggest here, is to quantify, and a life estate is an alienable asset, and there is methodology for quantifying the value of that asset that's been promulgated by the federal government and is done in estate planning and estate administration pretty frequently, and I would say would not be unexpected to be done the same way here. We've never gotten to that issue, so I can't quantify that for Your Honor because it's those petitions to partition that have brought forth the issue that have raised the questions to bring before you today.
And how does that comply with the statute language which says that your client gets above the $25,000 only the income during his or her life?
I think you can't stop reading the statute at that point because it then goes on to define what that means. And
Right.
with respect, if it,
It defines only the income of his or her share of such estate. And the estate that she has, the estate now is the personal property, which is to be held in trust, and the real property, which now you are invested for life. But why are you entitled to more than only the income, where the statute says only the income?
and that's where I think you can't read just that section, because then what you'd be saying, Your Honor, is if this was pasture land in Gardner, there would be no income from it, and that surviving spouse who's waived the will gets zero. There's not a mechanism within
Well,
this.
that's
and
why you get the 25,000 off the top.
That would be actually a retraction from what the old common law
It would be.
positions would have been, and clearly that was not the
Because
intent of the legislature.
the common law in the prior statute was the one-third life estate.
That's correct.
Okay, thank you.
Thank you.
Ms. Remillard.
Good morning. May it please the court. My name is Maria Remillard, and I represent Brenda MacGrath and the 4 surviving children of the decedent. The personal representative should have received a summary judgment in her favor, as this case certainly presents a pure question of law with respect to the 3 questions reserved and reported by the probate and family court.
Can I ask you, why should our case law go backwards? When you look at the prior statute and derivative of the common law, and then you look at what we wrote in our 2 decisions, Sullivan and Bongards, if we follow your interpretation, there is no vested one-third life estate, correct?
I don't believe that that was the focus of both of those decisions. With respect to Sullivan and Birkin and Bongards and Millen, the focus was what consists of the probate estate. It was this court's trying to determine what is the estate of the deceased,
Well,
where Sullivan...
Sullivan, we were trying to protect the surviving spouse from kind of the go-around by the trust, correct?
Yes, in a long-term marriage, yes.
Right. Right, but I mean, the statute's silent as to how long the marriage is here, right? It just says surviving spouse. It could be a day, it could be 20 years, right?
It could be, and that was part of the concern of this court in both Sullivan and Bongards in requesting that the legislature update the statute or at least do some
Right,
modifications.
but here we are.
And here we are, and the legislature still has not changed, although they've been valiant.
So the question remains, if we go your route and we say that the income, that phrase modifies both real property and personal property, so there is no vested alienable life estate, correct?
I don't believe so.
Aren't we going backwards from the common law and from the prior version of the statute?
I don't think so, because first of all, we're looking at statutory interpretation, and so the common law doesn't come into play with respect to that. As far as prior statutes with respect to 191.15 and the various iterations, I didn't get my hands on all of them, but there were various iterations. Prior to 1956, this statute provided for a surviving spouse to claim his or her intestate share and provided certain restrictions. Prior to that, the statute explicitly indicated that it would only be the income of the excess in the personal property.
Do you think the statutory language is unclear?
I believe it's unclear and I believe it's ambiguous, yes.
Okay, so if it's unclear and ambiguous, aren't we entitled to look at the history of the statute and look beyond the words of the statute for its meaning?
I think you first have to primarily look to the four corners of the statute and then
but
look for.
Unless it's unclear and ambiguous, which you just told me it was, so.
Right, but that's, but by looking back at the history and the common law, it doesn't necessarily give a right to rewrite the statute, which is in the providence of the legislature, which the Sullivan case and the Bongards case clearly indicated that it is up to the legislature. There was a constraint to go far beyond it. I think that the cases, prior cases, made very clear, the two cases, that this statute is woefully inadequate for a long-term marriage. We're talking about a 1.5-year marriage here, and again, the statute doesn't state that, but I think that this is certainly not a case to go well beyond the parameters of the statute and extend it to convey a greater interest than what is explicitly provided under the statute.
Do you believe that most practitioners would think that this statute provides for a life estate? And they'd be surprised by the interpretation that it doesn't?
I do not believe that most practitioners who regularly practice in probate litigation believes that it provides an unrestricted life estate. No, I don't believe that.
Can I ask you to, sorry,
No, I'm done, yeah.
Can I ask you to walk me through your interpretation of the statutory language? Because I
I'd be
find
happy
it as clear as mud. So walk me through the exact language. So, except that in either case, if he or she does take real or personal property to an amount exceeding $25,000, that's easy.
Right.
He or she shall receive, in addition to that amount, only the income during his or her life of the excess of his or her share. Do you agree with your brother's interpretation that her share is a third? Is that, you both agree with that, or is that's derived from somewhere else in the statute?
I believe that her share is a third of the personal property and a third of the real estate property, but then we go into the statute
Okay,
where.
bear with me for a second. I just want to make sure. And you get that share being defined as a third earlier in the statute, even though this last proviso looks like it's sort of an independent proviso, but you go up to her share up above, right?
Yes,
Okay, so you both agree with that. So her share of such a estate above that. Then you go into this language, and you say there's a comma, so the personal property to be held in trust. Both of those are governed by the income provision in the earlier part of the sentence, right?
the income provision, I'm sorry,
Except
the
exceed-
1/3.
I'm just going to read it backwards again. He or she shall receive in addition to that amount only the income during his or her share of the excess of his or her share of such, only the income during his or her life of the excess of his or her share of such estate above that amount. Then there's a comma, right? It
Yes,
says the personal property to be held at trust. So the income from the personal property and the real property vested in him or her for life, all that is modified by the clause before it, the income. Is that right? I just want to make sure, because then I'm going to ask you to do the same math he just did. Okay?
I would say so, yes.
Okay, but
Although
you don't say that with a lot of
there's one other
confidence.
provision that had the $25,000 because, that we didn't talk about, because it said, except if it,
No, we just read that. Except that in either case, if he or she would thus take real or personal property to an amount exceeding $25,000 in value, that's us here in this case, he or she shall receive in addition to that amount only the income during his or her life of the excess of his or her share of such estate, which is 1/3, the personal property to be held in trust. So the income from the personal, I don't know, and the real property vested in him or her for life, what does that mean, the real property vested in him or her for life? The income vested in her? What is that?
It's my view that it's the income vested in her for life. So any income that the real
It
estate.
doesn't say that. It says the real property vested in him or her for life, right? But
It does say that.
right.
But prior to that is she's entitled to only the income from the excess of her share. So we need to read it together.
Before you do Justice Kafka's math exercise, can I ask you a hypothetical from that?
Absolutely.
All right, I'll give you a respite for a second. All right. Suppose in this hypothetical, very simple situation where there's a single-family home, husband and wife live in that home. One of them dies. The surviving spouse is not in the will and elects their share pursuant to this statute. Does the surviving spouse have a right to live in that house as under a life estate? Or are you just saying that, no, they get the income from it, they leave, and if that's rented, they get the income?
I need more facts because under this statute, depending on whether or not the decedent left
Right, no,
kindred, or did not leave either kindred or issue.
Assuming there's issues, assuming that it's a 1/3.
And assuming there's over 25,000.
Yeah, and assuming that they peel off the 25,000.
Okay, so under that scenario, over 25,000, with children of someone else.
Right.
Right.
The surviving spouse, under other provisions of the MUPC, has a right to stay in the home rent-free for 6 months.
Okay.
It's not cited in my brief, but it is under the MUPC.
All right. What
So
about the
that
life-
right absolutely is
But
in
where is
there.
that? What provision is that?
It's under the MUPC. I can supplement with a 16L letter, and
What
I'll be
about
happy to.
But what about the life estate?
But I wouldn't call it a life
Okay,
estate
you're
with
saying,
respect.
you're saying it's an income, they get the right to income.
Right to the income, whether or not there is any income or
And your
not.
brother would argue, no, they have a life estate in a vested life estate.
But if he argued that in this court so found, then the surviving spouse would effectively be entitled to more than that 1/3 of the real estate that we previously discussed. Because under a life estate, you have a possessory estate, you're entitled to the whole, and you're entitled to any rents or profits, or you're entitled to live there. There's rights of occupancy, all of which those rights and obligations are absolutely silent in this wonderful statute.
So you're saying there is no life estate in this statute? This isn't providing 1/3 of a life estate at all?
I'm saying that, correct, that it is not an unrestricted life estate, because if there was an unrestricted life estate, traditionally, a life estate would have benefits that go well beyond only the income.
And that's your windfall argument.
Well, the windfall argument is twofold. One is, yes, it's a windfall because if this court were to hold that she has an unrestricted life estate, she'd be entitled to stay there as long as possible. And that sort of fell into the counterclaims of the children with respect to ouster and waste, because then there'd be corresponding obligations.
And the ability to sell and reap a lot more than 25,000 in some estates.
I wouldn't say that she would be able to sell, because with respect to her
Sell
1/3
her
share,
interest.
she could sell her interest as a life, so if it was an unrestricted life estate, she'd be able to sell her interest in an unrestricted life estate or even a 1/3 life estate, but she couldn't go forward to divest the remainders, who I would say that if this court found that she has a life estate, the remainders of that 1/3 share of the real estate necessarily have to be the beneficiaries under the will. And under this will, it's really the residue. If there was a specific bequest, that's a different story and a different set of circumstances. But here, when I look at the statute and I apply the statute to the facts of this case, 2/3 of the real estate, I think unquestionably, is the children's, the 4 children's. It's that 1/3 share that my brother and I dispute as to how it's applied and how we go forward with that and how the statute is applied with respect to that
So as it
1/3.
relates to that 1/3, I just want to make sure I understand this. In your interpretation of the statute, as it relates to whatever we're going to call that life estate, if the property is not sold, if the surviving spouse doesn't live there after 6 months, it's not producing any income, that life estate's of no value, in your interpretation.
That life estate, there would not be income.
Okay.
Correct.
Well, you don't want to
But-
call it a life estate.
Whatever it is.
I was going by
But no,
Justice's
but
words,
whatever
but
it
yes.
is, whatever it is, under your interpretation of statute, they've been married 50 years, let's say, and the 6 months have passed, whatever we're gonna call it, that interest, if it's not producing income, is of no value to the surviving spouse.
Unless the surviving spouse and the beneficiaries agree otherwise.
Oh, just on the
But
statute, on your
Under
interpretation.
the statute, correct.
So, I mean, isn't this sort of a punctuation problem? I mean, I think your interpretation is that it should read, or we should read it to be, above that amount, dash, dash, or that the estate is, that is, you get the income of the excess of his or her share of such estate above that amount, and then you understand the next phrases to be the estate being the personal property to be held in trust and the real property vested in him or her for life. So you understand that essentially to define what the estate is from which the income is derived.
Correct. The estate, that 1/3 that we had previously referenced.
Right. So if they had put dash, dash as opposed to comma, and separated that as defining what the estate means, we would be in a much better position. But that's what you say we should do.
I'm not sure with respect to the punctuation because I go back to the phrase of the excess of his or her share of such estate. So it's the excess of her share. Her share was previously defined as 1/3 of the personal property and 1/3 of the real estate.
Okay. And don't think you're going to sit down unless you answer Justice Kafka's question.
Oh,
I have 2 things. One, with the chief's permission, I'd like a 16L letter addressing this provision that deals with the 6 months, because neither brief references that. I have no idea what that is. But then can you do the math, assuming $100,000 in personalty and $400,000 in real estate?
I did the math based on the record.
Yeah.
So on page
It would be helpful if you could do the 100,000 versus 400,000 for a second, just so that we comparing
Okay.
apples to apples.
And I just refer you to page 12 of my brief, only because that takes the values in the record as opposed
That's
to the
fine,
100,000. So if there was 100,000 in personal property and
And
Susan's
400,000 in realty.
and 400 in realty, Susan's share of the personal property would be approximately $33,000.
So hold on, just do the math. She gets the first 25,000, you agree, right?
No, I don't agree, because further down in the statute, it says such only $25,000 absolutely to be paid from his or her share, of which he or she is interested. So when you look at that, that tells me that the legislature is saying that $25,000 is not paid off the top. That $25,000 is paid for from that 1/3 share in which he or she, the surviving spouse, is interested in. So in your example of the $100,000 of personal property, there would be sufficient funds to pay that only $25,000 absolutely from the surviving spouse's share. So you take the $33,000 less the $25,000, it is about, I hope, $8,000. So that $8,000 that remains after the payment of only $25,000 absolutely from the surviving spouse's share would then be put into trust to be administered with the net income to be distributed, as would with respect to the real estate. Here we have sales of real estate that occurred after
Just so I understand what you're saying. So we don't even get, she doesn't get $25,000. She gets income off of $8,000 and income off of, no.
She gets $25,000 absolutely. So of that $33,000, the personal representative would say, here's $25,000.
Okay, I got you.
And then because it's more than $25,000, the remainder, at least with respect to the personal property, would be $8,000. So we look to the terms of the statute that says in trust. So it's placed in trust, and because her interest is only the income of the excess, she's paid the excess for life, excuse me.
Okay, and then the realty, so now we have $400,000 in realty. What happens to that?
I have another question for you, and I apologize because under the circumstances of this case, we've had the sale of 3 parcels of real estate. So were we talking about real estate that is
I want to
parcel?
keep it simple, just $400,000 that hasn't been parceled out or anything. You just got $400,000 in realty, like Justice Gaziano's hypothetical. That house was $400,000. It was a $400,000 home. Go ahead. So she gets a 1/3 of that $400,000. The income of that held in, go ahead, how does it work?
Well, that would be a non-income under that hypothetical,
Oh, but
or
that-
actually, under the hypothetical was the or one of the hypotheticals is the surviving spouse was not living in the home. So
No,
if the
No, we're giving you the following thing. You've got issue for over $25,000, and the spouse, that house is sort of intact, you know? You just said that we look to another statute to decide who lives in it, but, so she gets the income of 1/3 of that $400,000, or are you saying she doesn't even get that?
she would get 1/3 of the income if there was any.
So she could get a big nothing out of this, is what
She
you're saying.
could get a big nothing out of the real estate. Just so, for example, 2 of the parcels left in this
So in
case.
your view, then, she gets 6 months to live in the house, but the house, whether the house produces income isn't what's contemplated by this statute. Okay.
Correct.
Wow, what a mess.
Yeah, so
Well, I mean,
after-
if she's not living in the house, there'd be an obligation to rent.
Absolutely, because just as a trustee of a trust has fiduciary duties, personal representatives certainly have the same type of fiduciary duties. Certainly if, as similar to this case where there was some acknowledgement between the personal representative, the decedent's 4 children, and the surviving spouse that some of these parcels of real estate needed to be held, there was the sale. Now it's a question of, well, what do we do with respect to the proceeds? And I certainly cited in 2 statutes in my brief, which I suggest that once you liquidate these parcels of real estate into now income-producing property, that it should be, she should continue to receive only the income of the excess of her share once she receives the only $25,000, absolutely.
Okay, I think with that, we'll take a morning break.
Thank you.